Welcome back. Please be seated. We'll call the next case this morning, Brevard County Clerk of Court versus Reemployment Assistance Commission. Let me just ask the appellee, are you all going to split your time?
Yes, we're going to split our time. The commission's going to go first, taking 15 minutes, and Mr. Cook has only asked for 5.
Okay, fair enough. Thank you so much. And do you want 5 minutes for rebuttal?
Please.
Thank you. You may proceed.
If it please the court, Andy Hammett, Ford and Harrison, Melbourne, Florida, on behalf of the Brevard County Clerk of Court. This is an appeal from 2 final orders issued by the Reemployment Assistance Appeals Commission awarding the appellees David Moissant and Mark Cook unemployment compensation benefits.
Let me ask this. Could the public reasonably rely upon Mr. Cook's campaign statements and promises?
Absolutely not, Your Honor.
So what you're suggesting then is that Cook can say anything that he wants during the course of a campaign and the public shouldn't rely upon it whatsoever. It's just, politics and that's all.
Just for the record, I think we're talking about Mr. Ellis's statements, Scott Ellis.
Statements.
Well, I hate to say anything and everything, but in the context of this case, these were plain and simple campaign statements. And this court has very clearly enunciated in several cases. The most notable is Smith.
Well, it went beyond statements made in the campaign. He also spoke to Needleman and told him the same thing that he had said publicly on the campaign. Could Needleman reasonably rely upon what he was told?
Well, as the commission finds, and I don't think it's undisputed, those statements did amount to the fact that there was uncertainty in their minds as to whether they'd have a job under his administration. But nevertheless, Mr. Ellis was not in office. He was not sworn in. This was a political campaign where people say lots of things.
So it's just, Ellis can go and make these statements during the course of the campaign, and the public ought to ignore what he said, and Needleman ought to ignore it, and the employees ought to ignore it because it's just campaign rhetoric. And I'm trying to look for the campaign rhetoric theory of defense.
Well, the example we use in our brief is President Obama. When he was running for office, he very clearly stated he was going to close Guantanamo.
Well, all politics is local, and here you've got a very specific statement made about the senior staff. And it's not uncommon that when one administration comes in and another administration goes out, that the senior staff does get canned.
Well, with due respect, Judge Cohen, it was not a specific statement in the sense that when I take office, I'm going to fire Mr. Cook or I'm going to fire Mr. Moissant. The record shows it was talking about reducing the executive team. And in fact...
They were the executive team.
Pardon me?
They were the executive team.
Not the entire executive team.
No, one person was out, 2 of the 3 of them.
That's correct. But no matter what spin you put on it, their campaign statements, it wasn't directed at them personally, and he had no authority at that point in time to do anything. So at most, it created an air of uncertainty, and that's to be expected in a political campaign. There's many times when employers have reductions in force, they have...
But this it's not a situation where, the Chicken Little scenario that you paint in your brief, where we're going to have one outgoing administrator saddle the incoming administrator by unilateral actions. I mean, here, Ellis had made these statements that resulted in the action that was taken.
It is still incumbent on the person to wait and see if they're going to lose their job and not quit prematurely. And that's what the triers of fact found in this case, the 2 initial appeals referees, that they had personally had no conversation with Mr. Ellis about continued employment.
it went to the commission, and then it comes back, and then the findings are different. We're looking at the second action that was taken, not the first.
Well, even the commission, if you look at their findings in their decision, and if you look at the commission's answer brief, they stop far short of saying that those campaign statements were good cause to quit employment. They do not say that. In fact, I think if we go back and look at their decision, they say that's not enough in and of themselves to quit. Because all it does is create uncertainty. And this court has said in the Smith case, which involved a Disney reduction in force, where they offered a voluntary layoff, and a woman quit because she was concerned she was going to be laid off. They were definitely laying off people. And this court said, we're not talking about uncertainty, we're talking about certain discharge. And in this case, it was incumbent upon them to wait and see.
Yeah. I don't know why, it just seems to me that your argument that Ellis can pretty much say what he wants and there's no ramifications to it, just is troubling to me.
Well, keep in mind, these severance agreements were, in Mr. Cook's case, he entered into it, I think, in November or December, a couple months before Mr. Ellis even took office. So under the theory that you're...
Election, though.
Pardon me?
It was after the election. And so, he was aware that Ellis had made these statements during the course of the campaign. One of the two was aware that Ellis had privately made the same statements after the election. I mean, it just seems that could reasonably be relied upon.
I would suggest that it would be very dangerous for the court to set a precedent here, that when a politician makes a statement during campaign...
I'm not concerned about, that the sky is falling because Ellis put himself in this position.
I think many politicians put themselves in the position when they come into office, they're going to cut the fat. And I don't think that means that any specific person is going to be terminated and invokes their right to flee and claim unemployment compensation. I think it's incumbent. I mean, this happens in every race. Anytime there's an acquisition or merger, there is likely to be a reduction in force. But it doesn't mean that you don't wait and see if your job is actually at stake before the taxpayers have to pay unemployment compensation. It's simply campaign rhetoric.
Yeah, I don't buy that. I don't buy it's simply campaign rhetoric.
I again would suggest that the court consider the ramifications of a politician being able to make a statement that they're going to be looking at cutting or reducing staff, and then that invoking the workforce right to quit and claim unemployment compensation.
Let me pose a couple of hypotheticals. At one end of the spectrum, we have the politician as a campaign promise that says, I'm going to, I think the office is overstaffed, I'm going to reduce the fat and get the workforce more in line with where it should be. I think we'd all agree if that's all that gets said, nobody can quit their job the next day and say, well, I was forced out, I knew I was going to get sacked, and that was the end of it. The other end of the spectrum, let's assume we'll just use Mr. Jones, make up a name. The politician says, I know that Mr. Jones works in that office and he's lazy, worthless, and the first thing I'm going to do is to get rid of Mr. Jones if I'm elected. And he gets elected. Is that a little different scenario than the general promise that I'm going to squeeze out efficiencies and reduce the fat? If you specifically say, I don't think that we need, even if the issue isn't Mr. Jones is lazy, the new person simply says, I don't think that we need the function that Mr. Jones performs, and I'm going to get rid of it, and Mr. Jones, because we don't need it.
Right.
I mean, is that different than just the general promise of, I'm going to squeeze the fat out of the organization?
it's not the facts of our case, but even in that situation, Judge Orfinger,
Glad that you explained that to Judge Orfinger, because otherwise he might have been confused and thought that those were the facts of your case.
Just help me understand.
well, I'm saying even in that situation, I think it is incumbent upon the person to wade through the uncertainty, and if they want to seek unemployment compensation through the unemployment compensation system, wait and see if they're actually told they're being discharged.
So, but what I'm really driving at is essentially that even if it's as specific as saying, I don't think that we need the job function that Mr. Jones performs, and my first act as whatever the office is will be to get rid of Mr. Jones and the office that he fills. That's not good enough either. That's just campaign rhetoric.
It is campaign rhetoric, because he doesn't have authority until he assumes office.
I understand. So, I was just trying to understand whether there was any scenario under which a statement made during a campaign that was not the general statement that we first described, but it was very specific, I'm going to get rid of Mr. Jones because that function is unneeded. The first day of my term, I will get rid of Mr. Jones. But your contention is that Mr. Jones needs to wait and see and can't assume that he really means what he says.
Correct.
Okay.
That would be my...
When I say okay, I'm not agreeing or disagreeing, I'm just acknowledging.
In the Rodriguez case, did Ms. Rodriguez have to wait until she actually got fired?
In Rodriguez, she volunteered for a layoff. It was as I recall, there was a budget cut, and the employer was trying to cut costs, and she volunteered for layoff.
Okay, and was she given unemployment benefits?
She was.
Okay.
And, that's the whole...
She didn't have to wait until she was actually fired, right?
That's correct. And both the clerk's office and the commission agree that that case was wrongly decided. I think it's also distinguishable from our case, but it takes us to the public policy and argument here, which is that...
Or how about in Sullivan? Was Sullivan wrongly decided as well?
Yes.
Okay.
Yes.
All right, so all the cases that hurt you were wrongly decided.
Well, and the agency that's charged with administering this act also agrees that those cases were wrongly decided. And the reason that they're wrongly decided is that they divest the Unemployment Compensation Commission of the authority that's been vested in by the statute to decide whether or not somebody is entitled to unemployment compensation. The law very clearly does that. If you look at the language of the statute...
Did the commission rely upon those cases when they reversed the initial determination in this case?
They relied upon them, but they stated in their decision that they felt they were bound by them because no other DCA had gone against them. But then they clearly say that they disagree with them, and if you look at the answer brief in this case, the commission agrees those cases are wrongly decided because they violate the statutory scheme under Chapter 443, and they violate the underlying legislative intent and the public policy behind them. In at least 2 or 3 different ways. Number one, there's a provision in the statute which prevents a waiver of rights and states that any agreement by an individual to waive, release, or commute her or his rights to benefits or any other rights under this chapter is void. And the commission and the clerk take the position that because Section 443.151 Florida statute gives an employer the right to contest claims, any argument in the severance agreements that the clerk waived its right is void as a matter of law under 443.041. More importantly, the statute plainly vests in the commission the right to make, the authority to make findings, well, actually, the Department of Economic Opportunity, to make findings and determine whether an individual is entitled to unemployment. Another section gives the department authority to determine whether somebody voluntarily quit with good cause attributable to the employer or engaged in misconduct. Other sections give the department the authority to appoint appeals referees to hold evidentiary hearings. If allowed to stand, the commission's decisions in these cases, and Rodriguez and Sullivan, which they follow, basically divests the commission of that right and allows employers in severance agreements to decide who will get unemployment compensation. In this case, Mr. Needleman purported to say, you know, you are eligible for unemployment compensation. The employer has absolutely no right to make that determination. That's up to the department and eventually the commission.
Didn't you say we're not going to contest your...
There was an ambiguous statement that said, we will not oppose, which is basically what the Sullivan-Rodriguez case has said, but here's one that says, if you are otherwise eligible. So it's more ambiguous. It was not as unequivocal as that. But again, you can't waive that right under the statute. If that's construed as a waiver, it would be void under the statute. And it's otherwise in violation of the statute and public policy, because Mr. Needleman had no right to decide who gets unemployment. And you can easily see how this can be abused, and departing officials can use these cases and this decision, if it stands, to just, at their whim, award unemployment compensation to their favorite people.
It's simple. I mean, here, you know, you had the statements by Mr. Ellis that don't, and that doesn't exist in every case.
Well, again, I firmly take the position that that's campaign
I understand.
and it's just as a matter of...
During the course of a campaign without, you know, any blowback on it. I understand.
Counsel, you've got 3.5 minutes.
I have one question. I just want to make sure I understand your position.
Sure.
Your position is that Rodriguez and Sullivan are wrongfully decided?
Well, we think they're wrongfully decided.
You argued they were distinguishable. If you argue that, then you're saying that they you know, it's still good law, but it's distinguished from this case. And I thought I heard you say that they were wrongly decided.
They are wrongly decided, and they are distinguishable. I think if the court doesn't want to reach that issue, I think they can be easily distinguished from the facts of our case. But if the court agrees that they're on point with the facts, then our position and the commission's position is they're wrongly decided. I'll hold my time for rebuttal.
Thank you, Counsel.
Thank you.
Good morning.
Good morning. May it please the court, my name is Amanda Neff, and I represent the Reemployment Assistance Appeals Commission in this case. In this case, the claimants had continuing work that was available to them, but they quit after they were promised eligibility for reemployment assistance benefits. In Mr. Moussan's case, he left a job that was continually available to him, in which he was making $68,000 a year, in order to receive a benefit that has a statutory cap of $275 a week, and it's temporary. And the statute requires that the inquiry be, are those circumstances that would compel a reasonable person to quit work? And I think that that would be a hard pill to swallow for a lot of people, that a reasonable person would exchange that for what is temporary and of a lesser amount. Now, the general rule in the courts is that quitting based on an anticipatory discharge is disqualifying. It recognizes fault on the part of the employees if they prematurely leave a job when they have job uncertainty. Now, what Martel and Rodriguez and Sullivan did was create an exception to that general rule where there has been some sort of representation by the employer regarding unemployment benefits. What it allows, what those...
You think those cases are wrongly decided?
I do, Your Honor. I think that they are in violation of the statute, and I think that It's just not good for public policy, and I'd like to get into those matters. Whereas the general rule recognizes
So you
default.
think this court should reverse?
Yes, in the unique position of an agency asking this court to reverse by conflicting with a sister court. Because those cases, they ignore the fault on the part of the employees in prematurely leaving, and they also ignore fault on the part of the parties in being ignorant of the law. And
Do you think that in the context of, even take it out of politics, if there's a pending merger and of two companies or an acquisition, and the acquiring company president says, I think that Ms. Neff's position, it's not so general as that first statement about we're going to squeeze the fat out of the organization, make it leaner and meaner and all that. It's very specific. We've got our own legal department, and we're not going to need the legal department that we're going to acquire when we merge with the Unemployment Assistance Commission, or whatever the proper name is. Would that be enough if your employer was so inclined to say, you know, we know you're going to get the boot, the merger's been approved, it's going to become effective in 2 months, so go ahead. I mean, or is the commission's position that you've got to wait and see?
the commission's position is that you have to wait and see. I think that bears out.
I'm just curious as to why, there's no realignment of the parties in this appeal.
I'm not sure if I understand your question.
It seems like you ought to be, that we're giving the position of, Mr. Ellis's case a greater amount of time than we're going to give to the opposite side. That really, your position is in line with the appellant, not really, the appellees.
Our position is in line with the appellant as to one issue. Our position was in line with the co-appellee as to the other issue in this case, which was that these cases are not distinguishable from the Martel, Rodriguez, Sullivan line of cases. And I understand that
Your position is that you had to rely on them, but you think that they're wrongly decided?
we're bound by those decisions, and we're asking this court to take a fresh look at the commission's interpretation of this and independently decide whether that interpretation is clearly erroneous, whether it's within the range of possible interpretations. If the commission's interpretation is...
They say they're distinguishable, but you say they're not.
I do not think they're distinguishable, and I think that it's clear that they were designed to not be distinguishable. The parties in drafting the agreement relied on those cases to ensure that they would not be distinguishable.
Do you think that no interpretation of that case law, you're saying that the interpretation of the statute through these cases and through the commission, it couldn't be supported? Is that what you're saying?
The commission's interpretation is different than the court's. The commission's interpretation is entitled to deference, and that's why I ask you to listen to the commission's interpretation and consider it freshly, and not just through the lens of those cases. Although those courts did not find it persuasive, you may. Now, the commission's arguments are based on the plain language of the statute. We think that the employer could not waive its rights to contest the claim through the no waiver provision, but it's not based only on that. And what we're asking is that the court find the agreement unenforceable against the agency. We're not asking you to find it unenforceable against the employer. Granted, that would not happen through administrative proceedings, but we're asking you to not hold it enforceable against the agency, because it does divest the agency of its exclusive authority that is clear from the statute to enforce the disincentives for prematurely leaving a job, and its ability to promote employment security through enforcing those disincentives. And the administrative scheme is really simple. The parties supply information, the agency decides. And I can think of no other agency that can be divested of its authority through just a pen stroke. And if you would think of, for example, parties that were engaged in a transaction to convey property, and seller tells buyer, the Department of Environmental Protection will grant you a permit for this property in the future. And then it doesn't. And then a court saying that DEP would be bound by that promise. It would,
Well, but if
it's,
it was DEP that made the promise, if DEP made the promise and said, if you will buy this property from Jones, we will grant you the permit. Don't you think in that case, DEP would be a stop then to come in?
yes, but
Okay,
in this
but
case,
here, you know, I mean, the employees were relying on these cases, and they were relying on a specific statement made by, as found by the referee, made by the successful candidate, that I think would lead a reasonable person in that position to think that my job is going to be gone the minute the new clerk comes into office. So, it isn't like a complete stranger to the transaction tries to bind the employer here. The employer, or the soon-to-be employer, and remember, it's really the office of the clerk. It isn't the clerk as a human being. It's the office of the clerk is the one that's being bound, and
but not only the office of the clerk. And that's where I want to go, because what it does is it also binds the agency, which was not a party to the agreement, and broader than that, it binds other employers and taxpayers. And I think that maybe I can best illustrate this by turning your attention to page 1 of Mr. Massant's record, which is his wage transcript and determination. Reemployment assistance is also known as unemployment insurance, and much like other types of insurance, it's a pooled risk system. And the interests that are at stake were not only the employers, or Mr. Needleman's and Mr. Cook and Mr. Massant. If you look at page 1 of Mr. Massant's record, it shows that there is another employer in the base period of his claim who is liable for any benefits that are paid to him. This agreement also bound that employer to be liable for the benefits that were paid. And in this particular case, that employer was liable for approximately 11%, whereas the Brevard County Clerk of Court was liable for approximately 89%. But those numbers could have been flipped, and they still would have been bound. In fact, this could reach a scenario where the Brevard County Clerk of
Did
Court...
the employer challenge this?
The other employer was not entitled to challenge it. They were not a noticed party in this issue. And they never are. But what could also happen in a scenario where the base period is the first four of the last 5 calendar quarters. If the claimants had only worked for Brevard County Clerk of Court in the last of the last 5 calendar quarters, they would not even be in the base period of claim, and they would not be liable for any of the benefits paid. All the other employers in the base period of claim would be on the hook for it. And I would also point out that because this is a public office that is supported by taxpayer dollars, those taxpayers are paying those benefits because the clerk is on the hook for 89% to reimburse dollar for dollar 89% of the benefits paid to the claimants, which is essentially coming from taxpayers. And to tell a taxpayer that you can quit a $68,000 a year job in exchange for temporary benefits of $275 a week and have them accept the idea that that's what a reasonable person would do would be a very difficult pill to swallow.
Well, maybe they would ask those questions of Mr. Ellis.
And they might. But in this scenario...
It just seems to me that the inverse might be true. I'd be hard-pressed to give up a good-paying job, $68,000 a year, in exchange for $275 a week for, was it 20 weeks or something? I don't know.
It's only 13 right now, Your Honor. It was many more weeks when the claimants had their claims.
So, I mean, it doesn't seem like that would motivate someone to prematurely quit unless they were really darn sure that their job was toast. I mean, who would get, I mean, that's what you opened your argument with, is basically nobody in their right mind would give up a good-paying job for 13 weeks of $275 a week.
That's right. And, but I would point out that it seems as though there was little, if anything, to lose by staying and waiting it out, whereas there is a substantial risk in joining the ranks of the unemployed, because one never knows how long one will be unemployed. And And that is the reason that one of the overarching goals of the Chapter 443 is to promote employment security. It favors employment over unemployment. It creates statutory disincentives to prematurely end relationships in employment, because we don't want people to become unemployed unless it's absolutely necessary. And I don't think here it was absolutely necessary. And I think that this court's precedent under Smith, which talks about the anticipatory discharge is not good cause to quit, could be applicable in this case if you were to conflict with the sister courts.
All right, thank you so much. You want to give the rest of your time?
I would happily give the rest of my time to the Calvary.
It pleases the court, I'm Mark Cook, I represent myself and Mr. Morset. It just seemed like there's been a realignment here. I believe that Martel, Rodriguez, and Sullivan were rightly decided based on the evidence and the facts. I believe the two independent...
Do you think that if Mr. Ellis on the campaign trail just says, we're going to make this office lean and mean, and that's probably going to mean reducing some positions, but doesn't ever get very specific, would that authorize the sort of agreement that was entered into here?
No, sir, I don't believe it would. Mr. Ellis was actually very specific about the management team, and that...
So you think the assertion made by the soon-to-be employer has to be, I'm going to eliminate, it needs to be very specific, and you think in this case it was, I'm going to eliminate Mr. Cook and Mr. Moisant. I don't know if I'm pronouncing that right.
Yeah, Mr. Morset, and yes, Your Honor, I think it has to be more specific than a general campaign pledge that, I'm going to reduce cost, or I'm going to make the office more efficient, something in a general, generic type thing like that, I believe would be different than the specific comments that Mr. Ellis made.
How do you address the argument that both of your colleagues make that this unlawfully, the opinions of our sister courts unlawfully impinges on the area of discretion vested solely in the agency?
Yes, I would disagree with that, because basically what the employer says is that they won't oppose, or, your eligibility will not be affected for unemployment compensation, and it's still the agency that makes the determination of whether or not you've qualified for that. And in this case, Mr. Morsant and myself both relied upon the statements of our employer, which was Mr. Needleman, that our jobs were at risk, that they would be eliminated, plus the public comments of Mr. Ellis in making the decision that we made to separate. So I believe that both, there were two independent appeals referees that came to the conclusion that we were qualified. They based it on substantial evidence. They actually, in Mr. Morsant's case, had a separate, new hearing with regard to his particular case. I believe that the opinion, the order from the Reemployment Appeals Commission was a correct order. I believe the order did qualify under the law, and I believe that Mr. Morsant and I reasonably relied upon the statements of Mr. Ellis and also our employer, Mr. Needleman, that our jobs were going to be eliminated. And by virtue of that, we were induced to accept the separation package. So basically, I believe that the brief that the commission submitted pretty much points out a lot of the different issues with regard to our particular situation.
I just don't, I didn't know exactly what the position would be today, but I just feel like that we've actually, that Martell and Rodriguez and Sullivan were rightly decided, and that your sister courts, the first and the third districts, made the right decision. I think it's reasonable. In one case, I specifically heard Mr. Eller say at a campaign event that when they asked what's the first thing you do as a clerk, he responded, the first thing I'll do is get rid of the management team. I think that's a pretty specific comment, and also Mr. Needleman.
If you had waited and he had done that, would you have been entitled to benefits, you believe?
May have been entitled to unemployment benefits depending on what his reasoning was for the separation, but the point is, I believe, is that we were induced to take the separation package because of the fact our jobs were at risk. And like you said, if you have a $68,000 a year job, you have to be pretty sure that your job is not going to be there in order to accept a $275 a week unemployment.
You understand, how this, can be gamed, and that you have...
Yes, sir.
Someone loses an election, and so the outgoing public official is going to assist their workers, and that's not the purpose of the statute.
Yes, Your Honor. Yeah, and I agree with that.
So why isn't that exactly what happened here?
Well, because it's absent the statements of Mr. Ellis. I mean, I think the clear intention was that our jobs would be eliminated. I don't think there's any question about that. And absent his comments, absent any sort of reason that we had to rely upon those, then I think you're correct. Then that would not have been a valid reason.
The department argues that invades the province of the commission. What's your response to that?
I don't think it invades, because they still make the determination on who's eligible and qualified. And basically, what our employer was telling us is that they would not oppose unemployment benefits for Mr. Morissette and myself. And I might point out, Mr. Morissette was unemployed for 2 years. So I don't think that impinges upon their duty, and neither did the first or third district in those cases we've cited.
Your time. Thank you.
Okay, thank you, sir. Thank you.
You've got, although I just cleared the clock, you have 2 minutes and 37 seconds.
I'll talk quickly. There's really two different issues here, as you can see. One is the effect of the severance agreements, and that's the real legal issue here. The campaign rhetoric issue is more of a factual issue. And I'd just like to point out, since the court does seem to be fixated on that issue, that the commission never found that that campaign rhetoric was good cause to quit. To the contrary, the original appeals referees made findings of fact to the contrary, and the commission, if you go through their final orders, found that that was not the case. They make the statement that the commission agrees, the record shows that neither the claimant was faced with certainty of discharge, nor that Needleman's advice that jobs were at risk once the new administration took over was based on anything more than conjecture. So the commission is finding that was not enough. The commission, in its brief to this court, is saying that's not enough. There has been no finding by the commission that that was enough. And to the contrary, the commission found it was not enough.
In the sense that Ellis hadn't given him a formal letter of firing him. That's how.
Well, what I'm trying to point out procedurally here is, in effect, this issue is really not even before the court, because there's been no cross appeal as to a finding that the commission should have made that campaign rhetoric was enough. To the contrary, they said it was not enough. So the issue's really not here. But we do firmly stand by our position, as does the commission, that campaign rhetoric's not enough. The point is, Mr. Ellis had no authority to do anything. He was in a political race. And the fact is, the jobs weren't eliminated. The record's very clear that Mr. Morsant was replaced, and that at the time of Mr. Cook's evidentiary hearing, his job was being advertised and was also being replaced.
So Ellis didn't do what he said he was going to do? Did he reduce the salaries of those positions?
There's no record evidence on that one way or the other, Your Honor.
Well, you were talking about it, so I figured we'd talk about it.
All right, counsel, you've exhausted your time. Thank you both.
Thank you.
Thank you all three so much.